Peace, everybody who's going to be tuning in from the replay. I'm going to be going over one simple thing in this video, and that's the question of, do I have to stay in the property the whole time while I'm doing this adverse possession? So I'm going to wait for for some people to get in, but if you're tuning in the replay, peace and love. What's up, everybody? What's up? So in this video, I'm going to be doing a quick little rundown on if you have to live at that property the whole time while you're doing adverse possession, because this is one of the most frequent questions that I get. And a lot of people have been asking me recently, like, do I have to stay there the whole time, or such? Do I have to, actively be there? And the question is, like, it depends on what you want to do with the property. So if you want to just, if you want to live there, obviously your ass going to have to stay there. But there's different things that you can do as far as with this adverse possession property that you do. Peace. What's up, Evergreen? I was thinking about our study session last night, our impromptu study session. But yeah, so for the people, again, just joining in, I'm going to be going over the simple question. The question that I get the most is, do I have to stay there at the property the whole time continuously? And so I'm going to read from these legal sources that I always have to, and let y'all know. Question: can you discuss different countries through the Commonwealth and Canada and Jamaica if you have time? If I have time, I'll discuss all that. But I want to read to y'all right now, like answering that question: do I have to stay up there? Yeah, that is a crazy word. So to answer that question is, again, it's depending on what you want to do. This is from American Jurisprudence. This is from one of the leading legal encyclopedias in the United States of America over adverse possession on the continuity of possession. And it says, what constitutes continuity of possession? Now, you need to listen closely because it's going to answer your question in here. The term continuous in the context of adverse possession means a possession for the prescribed statutory period that is uninterrupted or stretches on without a break, or a possession for the statutory period that is uninterrupted and without lapse. Now, highlighted this for a reason. Continuous possession, however, need not be constant or unceasing in order to support an adverse claim. In order to acquire title by adverse possession, the law does not require that the claimant be actually on the land during the whole of the prescribed statutory period, or remain continuously on the land and perform acts of ownership from day to day. So that's telling you that you don't have to be on there every single day, but you have to be there enough to let the outside world know that somebody lives there and own it. Daily or weekly use of the property, therefore, is generally not required to establish continuous use for purposes of adverse possession, as long as the use is continuous enough to indicate prolonged and substantial use. So you might want to, keep up with the property. That lets people know that someone's living there, someone's occupying that place, or someone has a claim on it because they're keeping up with the property. So that answers your question as to if you have to stay there the whole time. But I'm going to read from case law. This is from Howard versus Kunto. In this case, where did I start at? This case speaking about the requirement of continuity, like I just read. And here I'm going to start right here. Two issues are presented by this appeal. Is a claim of adverse possession defeated because the physical use of the premises is restricted to summer occupancy? So this case is specifically about somebody claiming adverse possession on property and they just use it for summer occupancy. In approaching both of these questions, we point out the evidence, largely undisputed in any material sense, established that defendant or his immediate predecessors did occupy the premises, which we have called Track B, as though it was their own for far more than the 10 years prescribed in RCW blah, blah, blah. We also point out that finding of Fact 6 is not challenged for its factual determinations, but for the conclusions contained therein to the effect that the continuity of possession may not be established by summer occupancy, and that a predecessor's possession may not be tacked. This is another thing I'm going to talk about, tacking on possessions, because a legal claim of right did not exist under the circumstances. We start with the often quoted rule that to constitute adverse possession, there must be actual possession which is uninterrupted, open and notorious, hostile and exclusive, and under a claim of right made in good faith for the statutory period. Now, this is what the court ruled, I think. We reject the conclusion from the other case. This is on appeal. So we reject the conclusion that summer occupancy only of a summer beach home destroys the continuity of possession required by statute. It has become firmly established that the requisite possession requires such possession and dominion as ordinarily marks the conduct of owners in general and holding, managing, and caring for property of like nature and condition. We hold that occupancy of Tract B during the summer months for more than a 10-year period by defendant and his predecessors, together with the continued existence of the improvements on the land and beach area, constituted uninterrupted possession within this rule. So even though they were using the house as a summer house, they still constituted uninterrupted possession and continuous possession. So that's another thing that people can keep in mind, that you don't have to be there all year. You can use it for whatever purposes. It just has to be continuous enough to let people know that, hey, somebody lives there, even though it's just a summer house. To hold otherwise is to completely ignore the nature and condition of the property. And I'm not going to read this right now, but I am going to get into tacking, because this is another strategy that people can use. Also, before I go there, people need to understand that possession has long been recognized as a means of acquiring title to property. And you get the title to property after you fulfill all the statutory requirements, and even how long you have to be there. And that depends on what state you're in. And possession adverse to the true owner may ripen into title by the lapse of time. What do you use to read case law? I use different things, but Google Scholar is one of the main ones that I use, just generally, because that's free and it's open for everybody. And that's one thing that people need to do. So I have a lot of tabs open right now. Howard versus Kunto. Also, when you click on the how cited, this is another way I study. If you click on how cited, it's going to go to other cases as well, in which that case, Howard versus Kunto, was used in the argument. And so this is another way to build your case law, library. Find out different ways and how this case has been used in other cases. What if the true owner is deceased? You want to find property where the true owner is deceased, because you're not going to get challenged in most circumstances, because a lot of these people, I won't say a lot of people, but many people are dying intestate. That means without heirs, without a will and stuff like that. And so these properties just sit there. They just sit there vacant, waiting to be sold by the state. And so why wait for the state to go get it if you can go claim it yourself? So that's the best opportunity. Those are the properties that I specifically mentioned in the ebook for people to go after. So let me go to Google Scholar. Go right there, you go to case law. Let's look up adverse possession. Right? Then you go over here, select courts, clear all, and you find your state. Let's do Arizona, because somebody today was talking to me from Arizona. Federal courts, clear. Because Arizona is one of the easiest states, because it's only a 3-year period, I believe. And so you just go down here and you find all the things about adverse possession. Or if you want to put in more keywords like, let's say, here's some stuff they already have. Statute. So yeah, that's how you would, if you want to get into it like I do and study from the actual case law, because this is going to help with your defense and it's going to give you an education inside of the case, because this is how I learned about tacking, which is the next thing. So let's say you find the property, right? Hold on while I find this real quick. If you find the property and you don't want to live there, what you can do, you can lease it out by tacking. Okay? And simply all that is that you're giving somebody else your claim, but they're still living there under your time period. So however long they're there is going to go towards your time period. And so I'm going to start here. Privity of possession between successive occupants of land as respect adverse possession may be shown by proof that the earliest occupant's possession and claim passed or was transferred by agreement, gift, devise, or inheritance. Privity may also be established by lease. So now you can lease these properties out, but again, you want to get properties that are truly vacant and abandoned because you don't want to be there and lease it to somebody else and then the so-called true owner steps back up or something like that, or their descendants. So you want to make sure you get the right type of property. And this is how I teach it, because you can then lease it out for the whole statutory period. And then that time that they're there, it goes to your time. And so now you don't have to be there. That's another way of getting out this, the continuous requirement by leasing it out to other people. And this is a strategy that I won't say I thought up, but this is something that I'm using now, I'm going to use. And so privity may also be established by lease, but you have to lease it out. In that lease agreement, you must put tacking clauses in there. Because if you don't, then now you're doing it the wrong way. And this is how a lot of people have gotten in trouble, but because they're leasing out properties that don't belong to them and they're not putting a certain verbiage in the contracts. And so they're getting themselves screwed over, and they're screwing over the person who they're leasing it out to. And so to protect all parties involved, you want to have the proper verbiage in the contract. How does this apply to descendants? So that question is kind of vague. So yeah, that's pretty much what I want to explain in here. You don't have to live there the whole time, and you can lease these properties out if you're doing it the right way. So if you have any questions, let me know. I'll answer a couple questions real quick. How does this apply to descendants? So the way it applies to descendants, let's say, I don't know. I need more specifics on that question. Can you charge by trespassing during the process of acquiring possession? You partially answered. Is there a way to do a search of delinquency on property search? So this is why I teach people, go look at the tax information. You can get the tax information from your county, what's it called? County treasurer. Yeah, the people who was in charge of the taxes in your county, that's who you talk to. And so I'll show you something real quick because I showed this last night. So I did a video, let me see, from this property, right? This is one of the properties that I claimed because I found this one. And after looking up the owner and stuff like that, I found that the owner has a business, that just went under, and they've been tax delinquent on the properties for 3 years. So right here, you can see these taxes haven't been paid. So total due for 2023, 2022, 2021. So next year, this property is set to be sold, but all I have to do to get it off the tax rolls is pay this amount, which I'm getting ready to do. And so it's not just on this property. I'm going to show you. Do I have it? Hold on real quick. Because there's a bunch of other properties by this business that's going under, and the owner of this, so there's I think about 10 properties that are all tax delinquent and about to be sold. So what I'm going to do, I'm going to get at least 5 of them, and I'm just going to pay taxes on at least 5 of them, and fix them up and rent them out. I'm already in the process of doing that, and this is what people need to understand, that since we're in a recession and stuff like that, a lot of banks, a lot of companies are going to be going under. You just need to literally be out there searching for properties and do your research on who owns these properties. Acquiring property. So, any other questions? But yeah, to answer that question, my bad, I don't know if I answered that question. You need to find out the tax information, because the tax information will let you know if it's delinquent or not. Especially if it's 3 years over 10 different properties. It's delinquent. Come on now. Something happened to the owner or whatever happened, that's not my business. I'm just going to, take advantage of the situation. And this is real estate. Real estate is very aggressive, it's very fast, and you have to be on it. How can I get listing to abandoned properties in my area? I'm in the Dade County area. So if you're in Dade County, Florida, what you need to do, you need to go do the same thing. You need to look up the tax auction list. They have some. I've helped a lady. Actually, I helped a lady get a property there because she's also in Dade County as well. And so there's a lot of people from Florida. Like I know a lot of things from Florida because there's a lot of members in Florida that's in the group. I'm scrolling up looking at questions right now. So yeah, a lot of people asking for that list. There's not, to my knowledge, there's not a specific abandoned property list unless you go get it from the code enforcement in your city or township. But I haven't been able to do that yet. And so what I do, I work through tax information and a tax auction list. And those lists aren't always given out all year. There are specific times during the year where they do the tax auction that you need to go look for. And that's when they give out a list. So over here in Tulsa last year, it was, I want to say, over almost 2,000 properties that were listed to be sold. And some of these, some people, they redeem their taxes before it's actually sold. So you also have to go drive around at any property that may look like it's, about to be sold. You don't want to just go pay the taxes because you might be doing a favor for somebody else. So you always want to, what I do is I highlight a property and I go there visibly. I go there physically to look at it, see if there's anybody living there. Is California difficult to gain adverse possession? The only thing, so the process is, I would say New Jersey is difficult because as far as like finding abandoned properties and stuff like that, New Jersey, they're doing some weird stuff up there. But as far as finding properties, that's up to you visibly going out there and looking for these properties. And so I won't say it's difficult to gain adverse possession anywhere if you find the right property. And I know a lot of people are intimidated by the amount of years you have to be somewhere, but I've never been intimidated. I've been here, for 4 years, and I'm not intimidated because I know like the property I got, it's abandoned. It was vacant. You got that information? Yeah, I got the tax information from the treasurer, but I looked up the property because I actually went there and I saw that it was vacant and abandoned. So when you're possessing a property and the property needs to be cleaned out and needs utilities turned on, you can live somewhere else while still, yes, you can. Because I have utilities on another property and I'm not even there. Which is another thing that people need to be aware of. Another sign of abandonment is no water running to the property and no electricity. So thank you, Miss No Patience, for saying that. It's California. Based in this question of rightful heirs. So yeah. Three years example, pay the tax for consecutive 3 years or pay on the property with 3 years worth of tax owed. Are you just making a statement or are you asking a question? Inside of whatever. If you pay someone else's taxes, don't they have to pay you back with interest to keep ownership? No. So if you pay someone else's taxes, you're doing that on your own, like at your own risk. So that's why you need to go and make sure that it's abandoned, because if you just pay the taxes and somebody lives there, well, you just help them out. They don't owe you nothing because they didn't ask you to do it. There's no contract between you and them. So I actually had somebody actually do that, and she was kind of a dumbass for doing it because she went on Zillow and got a $500,000 property. It's brand new, still being built, and she went ahead and paid the taxes. I'm like, why would you do that if they're still building the house? So don't be a dumbass with the process. It's a question. Okay, so ask that question again. Inside. Inside of Delia's synapses. I think that's your name. That's a long ass name. Inside of Delia synapses. I don't know. Isn't that a tax lien through the county? At least that's what I heard. So a tax lien, uh, yes and no. Depends. Each county is different. So over here, in Oklahoma, you have 3 years to pay taxes, and then they'll sell the tax lien at the auction. So I guess so. So I guess yeah, for the year 2021 in one of these properties, there's a tax lien on the property, and so you can redeem those taxes just by paying whatever year. That's in Oklahoma. I know in Miami-Dade County, you have to redeem the whole thing, and it can get up there. It can get pricey. What's her face? Who is trying to come up here? I guess I'll accept. I mean, I just accepted your request. I don't know why it's not letting you join. Peace. How you doing?
Awesome. How about yourself?
Great. How you doing? Me. What you up?
Hey, I'm getting my car clean, the
Okay.
cabans clean, but I wanted to be in on the class. That's all.
Oh, okay.
Maybe
So
I wasn't supposed to request because I was
yeah, yeah,
listening.
yeah. I'm just going live right now, so you can just drop out and still be listening. I'm just answering
Okay.
right now.
Okay. No problem.
All right. Peace.
Peace.
Where did one chick go? So she said 3 year example: pay the taxes for a consecutive 3 years, or pay on the property with 3 years worth of taxes owed. So yeah, I would say yeah, you pay on the taxes. So in Arizona, for instance, since that's 3 years, you would pay the taxes for the 3 years, and occupy the place. Can you please explain as this applies to jurisdiction? Does the property have to be paid for 3 consecutive years, or can one pay for 3 years worth of taxes owed at once? Yeah, that's either or. So you can pay each individual year, or you can pay all at once, depending on how your pockets are. So yeah. So what do you mean? Can you please explain as this applies to jurisdiction? Jurisdiction meaning like what? Isn't taxation in and of itself administrational theft? Yeah, I mean, so let me clear up some stuff right now. So when I teach adverse possession and stuff like that, I'm not getting into anything else. I'm literally going by the book. So we're not talking about nationality. We're not talking about any of this other extra shit that I know is real. I'm just trying to get people to get property, and not have to pay rent, mortgage every month. So once you get that property and all that, then you can address those issues. So you can go after the taxation and try to get your house off of the tax rolls. So, but everybody's not at that level. And so I'm teaching at a level that's literally uniform, no matter what, where you are in your process as far as like sovereignty and stuff like that goes. So this process is very basic. And so like if you have all that knowledge and stuff like that, I would say go get your property first, claim it, do all the stuff you got to do. And then once you got that secured, go attack all the, background issues that is going on. So as far as jurisdiction, nationality, and stuff like that, go ahead and do that on your own, and on your own time. California is 5 consecutive. I think so. I think California is 5 years. So the further you get on the West Coast, I'm seeing that the lesser amount of years that you have to do. So yeah. So as it applies to the UCC codes, bridges the gap, see all that stuff. Like I'm literally teaching like basic stuff. So what you hear me speak and what you hear me like teach about, stay on that. Don't go into anything else because I'm not trying to combine different processes. Yeah, Ohio's like 23 years. So yeah, a lot of people think, my perspective is like a mortgage is 30 years. What's the fucking difference? I mean, everybody's gonna be paying rent and or a mortgage to somebody. You're gonna be going from apartment to apartment. So why not just try to find a place? It doesn't matter how many years, because if you can spend 23 years without having to pay rent or mortgage, how much money can you save? So it's all about perspective. Pay for 3 years and then what? So after you pay for 3 years, let's say specifically, if you're in Arizona, so Arizona is a 3-year state where you have to have adverse possession for 3 years. You have to occupy the place for 3 years. After the 3 years is over, you have to do a quiet title suit. And since there's not going to be any owners and stuff like that, it's automatically going to be granted to you because you have nobody, you know, going against you. So you just go file quiet title under adverse possession, and you get a clear title. So after that, you can either continue to live there, or you can sell the property legally. And this is why I tell people, like, let's say buddy from Ohio, he got a property, but 23 years seems like a long time for him. Well, what he should do, and I'm not attacking, by the way, what you should do, you should just lease it out for the whole amount of years. And then after the 23rd year, go do a quiet title suit. This is a long-term strategy. But as it is, because it's a long-term strategy, you can still be making passive income every month just by leasing it out. Peace, bro. How you doing? So yeah, don't be intimidated by I think Jersey is 30 years. Don't be intimidated by that, because if you claim if you claim the right property, you won't have to worry about all that stuff. Peace, bro. How you doing? Trying to get people educated and, enforcing the law. And that's another thing. Like, if you look at if you look at adverse possession, it's not just some statutory law. It's actually common law, and it's protected by the Constitution under the Fifth Amendment, because you have the right to life, liberty, and property. And as I read earlier, I'm gonna read it again. It's very fucking ancient. Possession has long been recognized as a mean of acquiring title to property, and possession adverse to the true owner may ripen into title by lapse of time. So let me go to another case, one of my cases that I always go to, Fraley versus Minger. Where's it at? Here we go. The common law doctrine and application of adverse possession has a long history, as early as 2250 BC. So we're talking about this long. The Code of Hammurabi discussed adverse possession and the misuse of land, including provisions that punished land waste, rewarded long-term development, and allowed one who worked the land of another for 3 years to take and keep the land, because this operates off the principle that land is better used than not used. And again, the state is just going to do what's called is cheating, which simply means it's going to revert back to the state, and they're just going to sell it back to a bank. A bank is just going to put a mortgage on the property, and we have another 30-year slave paying a mortgage when they're not supposed to. Because even in the Bible says, don't you're not supposed to be shaking pledges and doing all this stuff, which is simply a dead pledge. So here's what it also says: adverse possession rewards the use of land and punishes those that sit on their rights. What do I think about bank-owned land? So this is where it goes. This is where it kind of gets confusing if you know that, banks technically can't own land. But however, since we're under this system and, they attack people all the time, I don't advocate for people to get quote unquote bank-owned property unless you're willing to go through that fight. But me personally, I'm not going to teach that, because I teach you to go through the road of least resistance. The properties owned by a bank are consistently going to be, more newer properties, or, they're already fixed up and stuff like that. And so that's the benefit there. However, they're going to be a real estate agent, actively trying to sell that property. And if they see you there, they're going to call the cops, and they can get you evicted, and they're going to try to get you evicted and stuff like that. And so if you think you can defend that on your own, that's up to your discretion. But me personally, I'm not going to teach people to do that. Does this work in Alaska? If so, where can one find the amount of years required to hold it? So yes, it works in Alaska. It works in all 50 states. So let's do this. Adverse possession Alaska. Also, I have it in my ebook. I have all the codes for the states. So with color of title is 7 years, but without color of title is 10 years. So that's not bad in itself because this goes by really fast. Send them a promissory note. Yeah, if you know how to do all that, do that. But again, like I said, me personally in this channel, I'm not going to teach people to mix processes. This is for literally everybody. So easy a homeless person can do it, which I have helped a homeless person. But that brought up something. You got me off track now. Yeah, it is a fake computer. Fake paper. Dang, that brought up something. I was about to look up something. Oh, color of title. Let me find that real quick because color of title is one of those things that's kind of tricky. But if you understand it, it can be used because all this shit is pretty much based off assumptions anyways, because everything is color of title under a democracy system. I'm still looking for it. Hold on. Because they talk about fraudulent deeds and all this stuff like that. Like, it's all fraudulent. But I would never teach somebody to, actively go do fraud. I'm just hoping people read between the lines and be able to, have discernment and do stuff on their own. Okay, I can't find it right now. Damn. That's a really good one, too. Also, let me read this real quick. When you do when you do a notice of claim, and I don't know if the brother's still on here, but he went through a court case. He actually told me this, but when you do notices of claims, which, by the way, they have the form for that. I just had it up here. When you do a notice of claim, they file it like it's a mortgage. The notice of claim required to be filed in Section 2 thereof, and this is in Oklahoma, obviously, you'll have to find it in your state, shall contain an accurate and full description of all land affected by such notices. The notice should set forth clearly the basis for and the extent or nature of the claimant's alleged interest, and this is your notice of adverse interest, and be signed, acknowledged, and filed for record in the county clerk's office of the county or counties where the land described therein is situated. The county clerk of each county shall accept all such notices presented to him which describe land located in the county in which he serves, and shall enter, record, and index the same in the same way that deeds are recorded. So just by a notice of claim, like, you're indexed in the records as somebody, pretty much the same as like a mortgage. And each county clerk shall be entitled to charge the same fees for the recording thereof as are charged for recording deeds. And indexing such notices in his office, each county clerk shall enter such notices in the index of deeds and the numerical index of deeds. The names of the claimants appearing in such notices are entered as grantees in such indexes. Can you get a loadial title for adverse possession for property in California? And again, that's mixing processes. So you're not going to be able to get a loadial title from anyone dealing in the public, because in I think it's 1913, right? 1913 or 1933, they converted all this shit over to mortgages and deeds. So loadial title is something that you have to enforce. You're not going to get that from them. And I'll reiterate for everybody joining in, the way I teach you is basic. If you want to do all the extra processes with nationality, UCCs, and all this other stuff, that's up to your discretion. I'm teaching so where the basic everyday man or woman can comprehend that these laws are on the books. Yeah. After the adverse possession, you get a clear title. Then it becomes allodial. Pretty much. Starts over. So any other questions? And I wish I had that thing so I can show you what it means by color of title. But just know that color of titles is pretty much all this BS that we're filing every day anyways. And it's all based off a presumption of validity, which is not valid. Does a bank give loans for, I don't know, you have to go talk to a bank. So if we don't have any, so for New Jersey, you don't have to wait the 30 years. I didn't say that. If you have color of title, if they have color of title statutes, you need to look in your state and see if they have a color of title statutes. If you have color of title, sometimes that means that you can lessen the amount of years that you have to, be there, occupy the place. How much of your book is 57 notes? Do you have to be a nationalist to use the remittance coupon? Nope. A nationalist? What is color of title? Good question. Let me pull it up. Okay. Color of title refers to a document or other instrument that appears to be legitimate. So it is an appearance, simulacrum, appearance from that, distinguished from that which is real. So again, color of title refers to a document or other instrument that appears to be legitimate claim of title to a piece of land, but due to a title defect cannot transfer or convey ownership. In other words, a person has color of title to a piece of property when, for one reason or another, the document evidencing title, a deed, for example, is invalid. Color of title is also known as apparent title. And so there's a presumption going on in the whole real estate game that all this stuff is legitimate, which in reality, all of it constitutes color of title. Because if you're on a colonized land, everything would be color of title because it's based off of presumption of legitimacy. Exactly. If we actually had the ability to enforce the rights of indigenous people, then the statutory constraints wouldn't apply to us. We wouldn't even have to be doing adverse possession. But I'm teaching this as a step up because it's even though we're in the system, there's still ways, to relieve some of the burden. And so this is one of those step ups for me, or that I view as a step up. Because again, if you're not paying the rent or mortgage, you can do so many other different things and you have more time to think and invest and do stuff for yourself. So that's what color of title is. Any other question? What is allodial ownership? Bro, I feel like you know the answer to these questions already. Unless you want me to explain for other people, which is fine. Allodial. Because now you're going to get me looking up the word allodial, which is going to go to feudal law. And this is what all modern real estate is based off of feudalism. Thank you for what you do. No problem. I'm trying to find allodial right now. Okay, here it is. Allodial, free, not holding of any lord or superior. So landlords, etc. Owned without obligation of vassalage or fealty. The opposite of feudal. So now you got to think, even with property taxes, that's still part of feudalism. Because why, if you pay off a mortgage, why would you have to pay property taxes? And if you don't pay those property taxes, they're going to sell your property. So essentially, you still don't own it. Because we have to go to the next level, which is, a lot of this stuff is going to be based off of nationality at the end of the day. But we have to work our way up because everybody's not at the same level. Yeah, he just asking questions that I already answered. Yeah, I got videos on that already. The difference between squatting and adverse possession. Thank you for asking these questions. I see what you're doing now. Squatting is illegal. Adverse possession is legal. That's the difference. How do you find property specifically for adverse possession? The best way I find properties is you have to look up the list of properties that's going to be sold on your tax auction, on your county tax auction. And you get that from your county treasurer. The best way, well, that's one of the ways. The best way for me that I personally found, is to go drive around. You said they are both legal. No, I said squatting is illegal and adverse possession is legal. But you know what? I got the dictionary right here, so I don't mind doing it. Squatter, in American law, one who settles on another's land, particularly on public lands, without legal authority. So if we look up adverse possession statutes, that's legal authority. A squatter can never gain prescriptive title to land, regardless of how long he holds possession, since his possession is never considered as adverse possession. So when they're talking about squatters' rights, that's an oxymoron. And everybody want to talk about sovereign citizens, an oxymoron. Squatters' rights is an oxymoron as well. Because this right here, and you can go look at the case law. A squatter can never gain prescriptive title to land, regardless of how long he holds possession. So you can never get clear title because since his possession is never considered as adverse possession. So this is one of the ways they trick people into thinking squatters' right is something actually legitimate. And I always read from here. Is it here? No, this is a different one. Where's it at? Where's adverse possession? Right here. Adverse possession is sometimes called squatters' rights, although squatters' rights are a colloquial reference to the idea rather than a recorded law. So I have all these books right here, and there's nothing on squatting, but there is something on adverse possession. And so squatting is not a recorded law. And this is what they're talking about. It's a colloquial term. So this is the term that's pushed by, the media and lawyers who don't want people doing this shit. They give you a false term, and then now you start using that false term as if it's something legitimate when you don't know that it's illegitimate. Once you take adverse possession, hold on, I'm gonna get to that question later. Once you take adverse possession of one of those properties, does that mean it will no longer be auctioned? No. To get it off of being sold at auction, you would have to pay the tax on it. So if it's delinquent, so for instance, I'll give you an example. So this property right here, delinquent since 2021, right? This is 2021, 2022, 2023. This is how much it's owed. So to get it from being sold, I would have to pay this first. This is going to take it off the auction for next year, 2024 auction. And so obviously you want to have to, keep up with these. You want to have to pay this off and pay that off. Or discharge it. I don't find these definitions clear, honestly. I still miss the point of color or title. Honestly, by definition, if I adverse possess property within the years prescribed and type of my own title, whatever. That sentence wasn't clear. No disrespect. Oh, I see. So yeah, that's one of the things that people need to look for. You need to go look at the tax information. Go look at the tax information because it kind of tells you a story about what's going on with the property. If somebody's not paying a property for 3 years, either they're falling behind on hard times, or somebody died, whatever, or they abandoned the property. Those who adverse possess the property. The stream is slowing me down. Yes, you have a lot of questions, and I get what you're trying to say, but I still think you're mixing all this knowledge that you have with something that I'm trying to keep very simple. So it's like, don't look at this as something that like one of those processes. This is something very basic, statutory law. Those who adversely possess the taxes and follow the rules. How do you get a load title? I don't really. Like bro said, you get a load title after you finish the statutory period and get clear title. And then after you get the clear title, you transfer it over to your trust. There. Does that help? Complete the statutory period, and this life is going to be saved, so you can go back. Yeah, and that's the thing about talking about a load title. I mean, if you want to get a load title, you got to get colonization off the land. You got to get back into a Republican form of government. So it's like I get what y'all saying, but it's like we got levels to go through. You're not just gonna find a process to get a load title. And that's not to say people haven't done it. Like I don't know. Maybe somebody has a load title that we don't know of, and they're completely private. But I don't know what they did. Would you recommend to discharge or to just keep paying taxes? Like I said, I'm not mixing processes. So go ahead and pay the taxes. That's what I'm doing on this property. I still pay the taxes, even though I know property taxes, it's complete BS. But sometimes just go along to just make it better for yourself, easier for yourself in this situation. Any other questions? Find a property that's going to be sold on auction through the county. County auctions aren't bank auctions. No, they're not bank auctions. But somehow a lot of banks and bank agents, I'll say, a lot of bank agents go to these auctions, or mortgage companies go to these auctions, buy up the property, stuff like that. If you look at what BlackRock is doing, that's a company. They're quote unquote buying up a whole bunch of properties. If I complete the process and print up my own title, does this qualify as color of title, which holds in administrational court? I feel like if you draw up your own title, and I don't know, that's hard to answer because it's based off whatever you can defend. If you draw up your own title, like what makes that legitimate? I'm asking you for you to answer for yourself. Like how are you going to defend that title that you draw up? Because like I can answer a question and stuff like that, but it's like what can you defend? And I'm not saying it's right or wrong. I'm asking you, that's a question for you to answer for yourself. Like how are you going to be able to defend that if you have to come to that point where you have to defend it? Get the clear title, complete the process, get the clear title, transfer it to your trust, and go from there. But I feel like people are caught up in this allodial title when allodial just simply, you know, like bro said, is without any superior or landlord over you. So you need to clear up any presumptions that's out there, or clear up any minimum contacts that you have with the state for them to be able to, get into your business. So you have to be living more privately and clear up any misconceptions that's on the record as far as being subject to their jurisdiction. Because even the legal description, that's color of type, that's colorable. They use legal descriptions instead of meets and bounds sometimes. Yeah, the process gets a clear title. That's the end goal of it. That's what I've been saying. No, you good. Just go ahead and get the ebook. You asked me too many questions. You got to get the ebook now. No, I'm just playing. But yeah, y'all go ahead and click the link in the bio. You're welcome, fresh to death. Any other questions, y'all? I'm finna get off of here. Don't do anything you can't defend. That's what I'm always going to stress to people. Don't do anything you can't defend. Don't just go get a template and think it's just going to work because it worked for me. No, that's something that I did. You have to have the knowledge, study to be confident enough to do something for yourself. And another thing, y'all need to stop. I won't say y'all, but y'all need to stop being scared to go talk to these people. I have like several people in the membership. They told me straight up like the most nerve-wracking thing for them is actually going to the county clerk and getting something filed. It's like, why? Like, people act like if you go there with certain paper, they're going to start fighting you. They're going to jump across things, start beating your ass because you're trying to get property. Like, what is this irrational fear that people have of a county clerk? Literally, one of the things that I did is that I got their handbook, and now I know what they can or can't do. Their handbook is simply the statutory codes on every state. So you can go to law.justia, and you can find that in your county code, and it just gives them it gives you all the rules to what they can and can't do. Statutes are literally, well, I won't say literally, but it's specifically for them and what they can and can't do. I'm not talking about no UCC codes. I don't do that shit. It's because UCC codes are under the same central banking system. Bro, you know all this shit. Don't be coming here trying to confuse me with UCC codes. You know the shit. Like, based on your questions, I know that you have a certain level of knowledge. And so what I implore for you to do, complete the process and then build off of what I'm doing. Hey, peace, Jet Raveler. So I'm going to have this live saved. I already answered that question. But, fuck it. I'll answer it again. Where do you find properties for adverse possession? So you drive around and you go look, and then you write down the properties. You go look at the county information on it. Go look at the county information on any properties that may seem abandoned. Go look up the tax information, stuff like that. Another thing you want to do, go to your county treasurer's website and look for the tax auction list or tax delinquency auction list, something along those lines. They're going to have a bunch of properties listed to be scheduled to be sold at the next auction. You want to find one of those properties. Again, write this stuff down. Physically go there. I keep saying visibly. The same thing. Physically go there. Check and see if the water's on. Check and see if the door's unlocked. Check and see if the electricity is off. All this stuff like that. And so if you find that it meets a lot of these, checks off the box and stuff like that, it's more than likely abandoned. And then the tax information is going to let you know if it's more than likely abandoned if you find that it hasn't been paid in years. So that's how. Did you get all that? Go get your county clerk handbook, because that handbook taught me something that I didn't know. Because even if they try to refuse your stuff, like over here in Oklahoma, there's a form called the Notice of Refusal form. Pretty much it's a writ of mandamus. It goes to a higher court, and then you're able to go. You're able to, what's the word I'm thinking about? State your claim in court, and if they found out that they're wrong, they have to file your documents. And I gave you proof to where you can find all this stuff. Like, one of my favorite states to look at is Texas, because Texas is very easy. I'm going to look it up right now. Texas adverse possession claim statutes. Where is it at? FYI, all adverse possession statutes are going to be under the civil practice or civil code under limitations. Limitation of personal actions. And Texas is really good. If I look up adverse, see, look, it actually states that. Adverse possession, adverse suit, adverse possession, blah, blah, blah. So they literally have the statutes and what you need to do. Adverse possession, 5-year limitations period, and blah, blah, blah. So this stuff is really easy to find. There's a 10-year limitation period. I think this is when you have 5 years in Texas is when you have color of title. 10-year limitation. This is how long somebody, a person must bring suit no later than 10 years after the day of cause of action accrues to recover real property held in peaceable and adverse possession by another who cultivates, uses, or enjoys the property. Without a title instrument, peaceable and adverse possession is limited in this section to 160 acres. So this is your limitation on how much you can claim, including improvements, unless the number of acres actually exceeds 160. And if you look at the case law in Texas, there's plenty of cases dealing with acres of land, over 10 plus, easily. Whereas in Oklahoma, they don't have these statutes. So that's why it's good for me. Well, it was good for me to, go through and figure out how to do it, because now I can go to any state and I can easily find, the adverse possession stuff, which is why I tell people all your adverse possession statutes, if they have any, is going to be under your civil code, because adverse possession is a civil matter and not a criminal matter. So police don't have jurisdiction in civil matters. And I heard that from a police's mouth when he came over here. And so don't be intimidated if a police shows up, because they can't do anything to get you evicted off the property. You have to stand on your rights and know what to do. And you always want to ask for a sergeant, because a sergeant knows this. Supervisor, sergeant, whatever they call. So don't be intimidated by that. Just because the police comes doesn't mean everything's over with. They're just nosy ass neighbors. And there's plenty of these, even on these media stories, there's plenty of cases where they say in the media story that the police can't do anything because it's a civil matter. So just know what you're dealing with, know your statutes, know the adverse possession is going to be found in your civil statutes. Hold on. Questions. Oh, here's what it is by color title. Found it. Again, I'm reading all this from, legal sources. This is from American Jurisprudence Pleading and Practice Form on adverse possession. Color of title. Color of title is that which appears to pass title, but for some reason fails to do so. A number of jurisdictions require color of title to be some written instrument. It can be a deed from one without the title to convey, or the means of conveyance may have been ineffective to pass title. So look, what does that mean to y'all? It can be a deed from somebody without the title to convey. So you don't even have to type the title to convey it. It still, constitute color of title. And then, again, all this is off presumptions. It can be the deed from one without the title to convey, or the means of conveyance may have been effective to pass title. In the absence of a statutory requirement, color of title is not an essential element of adverse possession. It does provide real evidence of a claim of ownership. The instrument or act relied on for color of title must purport to convey the property involved to the adverse possessor or his or her predecessor in title. What constitutes color of title is a question of law to be determined by the court based on the facts of the case. The instrument may be a void or voidable deed, a fraudulent deed, a forged instrument, a judicial sale, a contract or mortgage, a tax deed, a will, a patent, or an arbitrator's award. Possibly an oral sale or gift will constitute color of title. These are all the things that constitutes color of title. And let me go back to law.justd real quick. I'm going to go Oklahoma statutes. Is it title? I think it's property or conveyance. I'm going to show y'all something real quick. Is it over here? All right, so it's not this one, so it's going to be this one. I'm going to show y'all something real quick. Presumption. Rebuttable presumption. Recording of affidavit. Okay, Title 16, recorded signed documents, rebuttable presumption. A recorded deed, a recorded signed document relating to title to real estate creates a rebuttable presumption with respect to the title that. So this is saying that a recorded signed document relating to title to real estate means that the document itself doesn't have to be legit. It has a rebuttable presumption. And so that means that somebody has to rebut it. And if somebody doesn't rebut it, guess what? It stands as law. That's a commercial maxim. An unrebutted affidavit stands as law. So with respect to the title that the document is genuine and was executed as voluntary act of person purporting to execute it, and blah, blah, blah. So even recording of affidavit. An affidavit covering matters named in Section 83 of this title may be recorded in the office of the county clerk in the county in which the real property is situated. There shall be a rebuttable presumption that facts stated in a recorded affidavit are true as they relate to real estate, its use, and this is another word you need to look up in the law dictionary, or its ownership. So now, let's go here again. We're going to look up rebuttable presumption. Rebuttable presumption. In the law of evidence, a presumption which may be rebutted by evidence, otherwise called a disputable presumption, a species of legal presumption which holds good until disproved. So now, if you find a property and someone's dead, how can they rebut that? How can they rebut your ownership when you do an adverse possession? Y'all get that? So this is why I tell people, go find these type of properties because they're all out there. So that way, you're still playing by the rules. As fucked up as it sounds, you're still playing by the rules. And again, don't assume that just because these real estate companies look all professional stuff that they're not doing any shady business, because there's lawsuits all over the place with these banks committing fraud. And again, I'm not encouraging anybody to go, commit fraud. I'm just saying, like, don't think that everything that you see out here is legitimate because they're wearing suits and ties. So, recording of affidavit, rebuttable presumptions. So let's go to Section 83. And this is what I break down in my ebook. Section 83, matters to which affidavits may relate. The affidavit may relate to the following matters, blah, blah, blah. Also, age, sex, birth. So this is how I put my children's birth on record. You file an affidavit instead of, doing a birth certificate. Death, relationship, you can put your trust stuff on here as well. Partnership or trust. But where's the ones I'm looking for? In your marriage, this is where you do common law marriages as well. You file affidavits instead of getting, marriage license. But here's the thing: possession and residence. So does that not go with adverse possession? Yes, it does. Because remember, we're talking about affidavit, right? So let me bring up. Again, American jurisprudence, pleading and practice forms, adverse possession. Matters to which affidavit may relate, affidavit of adverse possession. And so this is how I connected all the dots, even with the notice of claim statutes. Because the notice of claim, hold on, let me find my book. You remember this where I just read this earlier, notice of claim. That's also supported in this book. I'll get to that question real quick, Delmore. I'll get to that question. Let me find what I'm looking for real quick. So, filing or recording notice, and then notice of claim. Generally, when applicable, statutes requiring the filing of notice of claim in certain cases will be given effect. And so, since Oklahoma don't have any adverse possession statutes, they have what's called, the notice of claim statutes. All right. So glad you asked that question, and we're going to transition on to something different. What if your state doesn't recognize common law marriage? Why do you need state recognition to recognize a common law marriage when you have the right to marry? Hold on, close the door, please. Or is that Kanan? Hey, Maddie, can you close the door? Is that Kanan? Yeah. Yeah, I figured it was. Um, sorry, my son trying to crawl in here. What if your state doesn't recognize common law marriage? So I just showed you. Matters to which an affidavit may relate. So you can do a affidavit of common law marriage and put in that affidavit your marital status. Because honestly, it's none of their business. Put it in the newspaper or whatever. That's what they do. So you don't need their permission. And I know that's an issue because a lot of people will be like, well, my state doesn't recognize it. But at the same time, under is it the First Amendment, where they can't, what's it, the First Amendment? Pretty much where they can't do anything against you contracting. I forgot which amendment that was. No state should pass a law, something obligations of contracts. I gotta find it now. No state shall. Anybody know that? There it is. Article 1, Section 10, Clause 1. So it's not an amendment. It's a contract clause. No state shall enter into any treaty, blah, 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 blah. No state shall enter into any treaty, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin, a tender of payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligations of a contract. So if you and your significant other enter into a private marriage agreement, can the state, pass a law saying that they don't recognize that? Or can they impair the obligation of your marriage contract? So again, it's not a loophole, it's the law. Okay, only for my woman, she's scared shitless of the state. Yeah, a lot of people are scared shitless of the state because they don't know their rights. But you just have to, explain to her what a marriage contract is and that's even better for both of you because you get to protect stuff better and you don't have the third party, which is the state, interfering in your private matters, your private affairs. So yeah. But that's a great question, though. I'm glad you brought that up. This all goes back to knowing your rights, anyways. Adverse possession is a property right protected by the Fifth Amendment. I'm not gonna get too deep into that. I already looked at all this stuff. But this is Chaplin versus Sanders, Washington Supreme Court, 1984. The doctrine of adverse possession was formulated at law for the purpose of, amongst others, assuring maximum utilization of the land, encouraging the rejection of stale claims, and most importantly, quieting titles. That's also supported in this book because it's about getting title to land. What is that? The goal of the doctrine of adverse possession is the final settlement of titles. Because the doctrine was formulated at law and not at equity, it was originally intended to protect both those who knowingly appropriated the land of others and those who honestly entered and held possession in full belief that the land was their own. Thus, when the original purpose of adverse possession doctrine is considered, it becomes apparent that the claimant's motive in possessing the land is irrelevant and no inquiry should be made into his guilt or innocence. And obviously that's talking about, this case. Again, this is Chaplin versus Sanders. Go read it, get your education. They give you sources, the law of adverse possession in Washington, the law review, all that. Other cases where it's used, blah, blah, blah. Washington is not the only state which looks to the subjective belief and intent of the adverse claimant in determining hostility. However, the requirements has been regarded as unnecessarily confusing by many legal commentators. For reasons, we are convinced that the dual requirements that the claimant take possession in good faith and not recognize another superior interest does not serve the purpose of the adverse possession doctrine. The hostility/claim of right element of adverse possession requires only that the claimant treat the land as his own. Let me read that again. The hostility/claim of right element, which is that's a requirement, of adverse possession requires only that the claimant treat the land as his own against the world throughout the statutory period. So that's the only thing that this means, hostility. What's the name of this webpage? This is Google Scholar. So you go to scholar.google.com, look up adverse possession, blah, blah, blah. The nature of his possession will be determined solely on the basis of the manner in which he treats the property. His subjective belief regarding his true interest in the land and his intent to dispossess or not dispossess another is irrelevant to this determination. Under this analysis, permission to occupy the land given by the true title owner to the claimant or his predecessor in interest will still operate to negate the element of hostility. So you can't have permission from a true title owner because that negates the element of hostility. Hostility just means, damn, I'm stuttering like shit. It just means that you're adverse to somebody else's claim. The traditional presumptions still apply to the extent that they are not inconsistent with this ruling. Yeah, I might as well just go through all the other elements since I'm just reading case law after case law. But I'm giving y'all where to go, how to research this stuff. This is another one. This is about continuous. Continuous possession is established where the claimant uses the property in a way that an owner of a property of like nature and condition will hold, manage, and care for the property. Thus, in Howard, occupancy only during the summer months of a beach home did not destroy the continuity of the claimant's use, where the surrounding homes were also used as summer recreational retreats. So yeah. Anyways, I'm done. Thank y'all for tuning in. I'm going to save this live so y'all get a lot of information from this. Thank you for tuning in. If you haven't got the ebook already, just go ahead and click the link in my bio and get it, or go to adversepossessionblueprint.com. It's well worth the price, and I'm not being biased. But thank you for tuning in as well. Y'all take it easy.